Pete Williams was inside the courtroom. He joins us now. So, Pete, let's talk more about what came up and how heavily was the 1967 case, Loving versus Virginia, referenced.
Well, let me just begin at the beginning, because I obviously haven't heard any of what you've said before. I just got out of the argument. And let me give you what I think the bottom line is. Number one, it's quite obvious the U.S. Supreme Court is not prepared to issue any kind of sweeping ruling about gay rights. No member of the court seemed to be very interested in that. Secondly, the Supreme Court, both liberals and conservatives, seems to be worried about writing a decision that will apply to any state outside California. Now, the proponents for the four gay couples that brought this case are really urging the Supreme Court to say that marriage is such a fundamental right that no state can constitutionally deny same-sex couples the right to marry. There seemed to be very little eagerness from any members of the court to embrace that broad a ruling. So then you go to the fallback, which is argued by the Obama administration. They're basically saying any state like California that gives all of the rights of marriage, the right to adopt, the rights, all the benefits, except for the word marriage, their argument is that any state that does that is unconstitutionally discriminating by just holding back the word marriage, that there's no principled reason for it if you're going to say that same-sex couples can do everything else that traditional couples can do. Very few members of the court seem to be willing to embrace that either. They seem to be bothered by the idea that if they did that, they're in essence punishing the states that are willing to grant all those rights and giving the other states that don't grant any rights to same-sex couples a free ride. So that leaves the only other option, which is to either uphold Prop 8 or to limit this ruling somehow, applying only to California. And that's where I think the real action is here, Thomas. I think several members of the court seem to be struggling to find a way to limit this case only to California. And one way to do that might be simply to say that the Proposition 8 proponents had no legal power to bring this in the first place. And I think, frankly, for the advocates of same-sex marriage, my guess is that's the best they can hope for. Now, one other thing I would say here, Thomas, is the justice we watched very closely was Anthony Kennedy. He seemed to say, on the one hand, that he's somewhat sympathetic to the arguments made by the two gay couples here. He said that he's bothered by the effect of Prop 8 on the children, the 37,000 children of same-sex couples in California whose parents cannot call themselves married. He made that point early on in the argument, but then he also said that he's worried about a decision that would apply to the entire country, and he also said he thought the basis on which the lower courts rejected Prop 8 was too narrow. So you put that all together, Thomas, and that's why I say I don't think the Supreme Court is prepared. And again, I have to just pause here for a second and give the caveat that, you know, this is right off the top of the notebook. The justices have a long way to go before they write their decision, so it's always very risky to make an assessment based solely on oral argument. Having said that, I think the most that the same-sex couples advocates can hope for is a decision that basically finds some way to strike Prop 8 down without having any effect beyond California.
And Pete, as you talk about Justice Kennedy asking the questions of imminent legal injury facing those thousands of children that you referenced that are growing up in same-sex households for their parents, they say that they want their parents to have full recognition and full status. This is according to reports that are in front of me right now. However, also, Kennedy said that this would be taking the Supreme Court into uncharted waters. That's the quote I have. But that Olson responded that the court did just that when it threw out bans.
Yeah. Let's be clear about what Justice Kennedy means by uncharted waters. He means taking it beyond California, applying the ruling of same-sex marriage to other states in contexts that are very different from California. That's why I say I think that the justices are very nervous about any kind of decision that would apply beyond the state.
But didn't the justices do that in a unanimous decision with Loving versus Virginia, where they were able to impose that beyond the state of Virginia to federalize it?
Right, and that gets to the other point here. Several of the justices said that they were concerned about, in essence, rushing things. Now, this is the argument, this is one of the main arguments made by the proponents of Prop 8. They basically call Proposition 8 hitting the pause button. and allowing the political process to play out. Justice Samuel Alito said today that he's concerned about recognizing a right to same-sex marriage that he described as newer than the internet and cell phones, and he said that the political process should be allowed to take its time. But some of the liberal justices did mention, as you did, that the court made a decision about interracial marriage relatively quickly, but the conservatives said no, actually that played out over many years. So that, I think, frankly, that argument cut both ways.
Was Loving versus Virginia relied on heavily in the arguments today, referencing it? No?
No.
And when we talk about the Kennedy bringing up the uncharted waters territory, that reference there, do you think that provides potential cover as we look at states' rights issues over the equality issue of gay rights in general?
Well, that gets into tomorrow's case when you're talking about states' rights. And frankly, states' rights was not an issue today.